If you have a passing interest in politics, follow the news, or live above a rock, you're probably aware of the fact that courts can overturn the precedents set by older cases. Which is kinda weird, right? Isn't one of the key characteristics of the common law system stare decisis? The concept that we follow and consult the rulings of past similar cases in deciding what to do now? Like, if a court rules a controversial protest is legal, then those protests are typically considered legal from then on. Why undo that precedent? Well, for an example on why courts might go back on precedents, let's look at Carter v. Canada, the Supreme Court case that decriminalized medical assistance in dying. Back in 2015, medically assisted dying was quite illegal under sections 14 and 241B of the Criminal Code of Canada. First, the code said a person couldn't legally consent to someone taking their life. And second, the code stipulated it was criminal to help someone end their life, be that ending someone's life yourself, providing someone lethal materials, transporting them to a specialist in euthanasia, etc. Now, this proved problematic for Kathleen Carter and Gloria Taylor, two women who, like many before and since, suffered from incurable degenerative diseases, ALS and spinal stenosis respectively. Both women desired assistance in ending their lives early to avoid suffering, and although they had both died before their case was finally decided, their team's legal process worked through the court system through the early 2010s until it reached the Supreme Court. Carter and Taylor's team claimed that the Criminal Code of Canada's prohibition of medically assisted dying violated Section 7 of the Charter of Rights and Freedoms, infringing on Canadians' right to life, liberty, and security of person, because criminalizing assisted death forces suffering people to take their lives while they still can, before they are debilitated by their condition, prematurely shortening a lifespan, while also removing their agency and dignity. The Canadian government countered this, arguing that the prohibition of MAID was necessary to protect vulnerable individuals from abuse and mistakes. To open up MAID would condemn our most endangered patients to undesired assistance in dying. In a unanimous decision, the Supreme Court ruled that the Criminal Code of Canada's prohibition of medically assisted dying was unconstitutional, concurring with a lower court that it violated the right to life, liberty, and security of the person, not because the court was against legislation on protecting the vulnerable, but because the current prohibition was too broad in its scope of prevention. Prohibition stopped everyone, but not everyone needed to be stopped. So yeah, the prohibition was struck down, and the next year, there was an election, the federal government enacted Bill C-14, which legalized assisted dying under these conditions. Now, the kicker here is that 20 years earlier, there was a very similar case that failed to decriminalize medically assisted dying, Rodriguez v. British Columbia. The Rodriguez case was essentially a carbon copy of the Carter case. Both were prompted by a person seeking to end their lives, both challenged 241B of the Criminal Code, they used similar arguments, and Sue Rodriguez even had ALS, just like Kathleen Carter did. The Supreme Court even agreed that Rodriguez's charter rights were violated, just like Carter and Taylor's were. So why didn't the Rodriguez case, allow assisted dying? Well, one of the main reasons was the rarity of medically assisted dying worldwide. In 1993, there weren't really any legislated schemes of assisted dying that the Supreme Court could look to and say, oh, that worked over there. And so, when the Canadian government argued that, hey, we need to have a blanket ban on assisted dying to protect the most vulnerable, the plaintiffs or court didn't have an example of a working protection regime to point to and say, but it works fine over there. And so, the complete ban was justified. This had changed by 2015, as successful assisted dying regimes had come about in countries like the Netherlands and in a few US states like Oregon. So now, the argument of a complete ban didn't really hold water, as other places were now successfully ending the lives of those who wanted them ended and protecting those who were vulnerable to abuse and mistakes. Thus, the infringement on charter rights went from a justified one to an unjustified one. There had also been some evolution in the principles of fundamental justice that changed how Section 7 was viewed in 2015 versus 1993. The view of overbreadth, when legislation has effects beyond its intended goals, had grown from a question of whether the prohibition was arbitrary or unfair, in that it is unrelated to the state's interest in protecting the vulnerable, to whether the law interferes with some conduct that has no connection to the law's objectives. And according to the Supreme Court, this different question may lead to a different answer. So the issue of assisted dying law going beyond protecting the vulnerable to full prohibition was less permissible. To answer why the Supreme Court changed its mind, the world changed. and the judiciary's conception of justifiable infringements and fundamental justice had evolved, and so the Supreme Court adapted its prior decision. What was previously a justifiable ban became unacceptable, and medically assisted dying became fully legal. Thank you for watching. Please like, share, and subscribe for more loving videos about Canadian issues. Have a good one.